Hello, this is Matt on the Moon Family Sedan channel. Today, the SEC, in the SEC v. Ripple case, filed a supplemental authority which would go straight to Judge Torres. And, the degree to which this is going to be impactful is questionable. It does seem that this is something that is, to be fair, good for the SEC. Is it something that's going to change the outcome of this case? Doesn't seem that way. And so I'll tell you this here at the outset of the video. An attorney thinks that the filing of this supplemental authority by the SEC might delay the end of this lawsuit. I kid you not. So there's a possibility that to some degree this would be perhaps one final freaking delay in this case, which has had, I don't even know how many delays as a result of SEC hoo-ha and nonsense. Although there is another attorney within our community who doesn't seem to think that this will result in a delay. And also, one of the attorneys, and I'm going to go through all the specifics here and share with you perspective from a couple legal minds in our community, but one of the attorneys thinks that Ripple will not lose on fair notice defense, which is at the heart of this most recent supplemental authority today, even though it technically is good for the SEC, and so it makes sense for the SEC to have filed this. Separately, I want to share with you a couple things from attorney Jeremy Hogan. He shared his thoughts on to what degree Judge Torres might understand the monumental impact of this lawsuit. And also, he was asked, effectively, if XRP is found to be a security, presumably we should have specific rights, from the seller as a result. That's what you'd expect, right? Well, because that would be Ripple. So would Ripple actually owe us XRP holders anything if the judge ends up ruling on that? I'll share with you what Attorney Hogan had to say, but before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Shout out and credit to James K. Filan, attorney and member of the XRP community. Just this afternoon, he shared this most recent development. And so this is what was written by the SEC to Judge Torres in the SEC v. Ripple case. I don't think it's necessary for me to read it, but if you do want to read it, feel free to hit pause. There's barely anything on the second page. It's just right there. And then there's a signature line. That's it. But all you need to know is that the SEC filed a ruling in a case, which concluded, by the way, April 7th. So this happened a few days ago. And in this particular opinion, which is a district court of Massachusetts, the court found that on the subject of fair notice defense, the SEC was in the right and the defendant was in the wrong. The defendant is called, let's call him Commonwealth, because that's what they call him in this document. The Commonwealth, what's the full name? Commonwealth Equity Services, LLC. Let's call them Commonwealth for short. They're the defendant. And they were ruled against here. And the reason that this was found to be relevant for the SEC v. Ripple case, not purely because it happens to be yet another instance of a fair notice defense not going so well for a defendant, but specifically because this defendant was referencing another case, the Upton case, which I've talked about on this channel. And Ripple is also, in their fair notice defense, referencing the Upton case. So there's the overlap, there's the commonality. That's the primary reason that the SEC ended up filing the supplemental authority today. But to what degree, if any, does this actually matter? Well, attorney Bill Morgan, member of the XRP community, retweeted that news from attorney Filan, and just a little bit earlier today, he shared his perspective on this, and he wrote the following. Thanks, James. Short and to-the-point letter from the SEC. This relates to the fair notice defense, which the SEC once decided against Ripple on its summary judgment motion. The defendant in this case, like Ripple, tried to rely on Upton v. SEC in a fair notice defense, but lost. The court found an old 50-year-old case gave the defendant fair notice. So it argues the Howey case and its progeny since then gave Ripple fair notice. The case, superficially at least, helps the SEC. But folks, so just make sure that we're clear on a primary difference here. This is a completely separate industry, and they found that there is clarity for this old industry, in which you'd expect there to be more clarity anyway, dating back half a century, right? And then on top of that, Bill Morgan then points out that this decision from the district court in Massachusetts, it's not binding, and so Judge Torres doesn't even have to consider it. Now, I'm sure she's going to read through this and she'll consider it, but in terms of how it would impact the ruling, no, it wouldn't have to. So the judge does get to do whatever she wants. I'm just saying, from a legal perspective, as Attorney Morgan points out here, this is not something that Judge Torres would actually have to act on when it comes to the summary judgment. She doesn't have to. So say she's just about got her summary, the summary judgment decision draft, whatever it is, about complete. She doesn't have to go back if this is way off, in terms of what she was writing, and then redo that. She doesn't have to. It's kind of like, here, take this under advisement. It's more like that. And so then Attorney Morgan said, it is not a binding decision on Judge Torres, and Ripple will seek to distinguish the case, different facts, etc. It's not hard. In no non-crypto case must the court deal with a new asset class as a fact or the misguidance to the market of a Hinman speech. Yeah, so he's pointing out that this is entirely different. Crypto's also brand new, and Ripple, they will have an opportunity to respond, unless, of course, there was actually a final ruling before Ripple got to it. But should we expect that? Well, that's a different topic we're about to get to, but let me go a little bit further first. Then Attorney Morgan says, I predict Ripple will not lose the fair notice defense at summary judgment just because of this decision. So to be clear, he's not saying in that sentence whether or not he thinks Ripple will or will not win on fair notice at summary judgment. He's just saying, as a result of this isn't something that's really going to move the dial. Now, it's also true, and we get to this, their opinions from Attorney Morgan and Attorney Fred Rispoli, another attorney within the XRP community, and they do indicate something that I've mentioned before, but it's worth reiterating here, because we're talking about the gravity of what this filing is. Well, in terms of fair notice, it's important to recall that the judge ruling on fair notice will only occur if something goes disastrously wrong for Ripple, and thus for XRP holders, in terms of Judge Torres determining exactly what has occurred with Ripple sales of XRP up to this point, or up to the point of the lawsuit at a minimum. So, because look, if XRP if is not found to be a security, and if there are no transactions from Ripple that are found to be infractions, nothing was illegal there, well then you don't even need to address the issue of fair notice defense. That's why. Now, somebody from the community named Tim responded to Attorney Morgan there and said, winning fair notice does not help ordinary retail investor. And so my response to that, the first thing I was thinking when I read that, I was like, well, yeah, I mean, we already got really bad news regarding XRP. It's in all likelihood anyway, if the judge is even determining that. And then that impacting XRP specifically, not so much. It's really more so like an insurance policy for Ripple, as how Attorney Deaton has phrased that in the past. And so Attorney Morgan wrote back and said, it would mean Ripple wins the case and will continue with the development of its particular service, which increases use of and utility for XRP. Yeah, so that's under the assumption that Ripple would win under fair notice. And then he says, most retail holders of XRP seem to believe this will increase XRP's price and benefit them. Yeah, so I can only speak for myself here, but I think having multiple participants in the XRP ecosystem, multiple developers building on top of the XRP ledger, that adds actual value, which is different than price. And I think that if there's something in cryptocurrency with actual value, that ultimately impacts price. But it's not like we're counting on one developer, Ripple, to increase the price. It's about the totality of the entire ecosystem. That's the point of a decentralized system. And of course, we should expect there to be actual value for a price to go up, because if there were no developers, why would the price go up? It wouldn't make any damn sense, which is a lot of what we have seen since the inception of crypto, because there's been such wild speculation. There has been some crazy stuff and ridiculous, irresponsible financial decisions made. There's been no shortage of that over the last 14 years that crypto has existed. But in a mature market, I think you see less of that anyway. And then there was also this. Somebody responded to Attorney Morgan and wrote, this only applies if the Howey test is an adequate measure for cryptocurrencies, though, right? And Morgan wrote, it is only relevant to the fair notice defense. If Ripple wins on the Howey test, not applying to Ripple's XRP sales, Ripple doesn't need to win on the fair notice defense, which is what I was getting at just a minute or two ago. Then there was this from XRP community member Irish Tiger, who wrote, he wrote this to Attorney Filan and said, thanks for this, Jim, but isn't a fair notice defense by Ripple only triggered if they lose a substantive issue. So it strikes me that this is the SEC trying to force a late settlement. And secondly, they may not have to defend because even if they lose, they win with XRP clarity. And attorney Fred Rispoli responded and wrote, correct. Fair notice defense is irrelevant if Judge Torres rules no investment contracts were ever created and Ripple wins entirely. Case closed. But if Judge Torres rules whether some or all of Ripple's XRP sales are for a jury to decide, only then does fair notice come into play. Then there was also this. Somebody named Mark wrote to attorney Rispoli and said, I want to start at the top here. Fred Rispoli, in a separate tweet, wrote, well, SEC just filed a notice of supplemental authority, re fair notice defense from a Massachusetts district court case. Although it's not super on point, this could delay summary judgment ruling, as Judge Torres usually gives other side time to reply to these notices. Sigh. And then Mark, a guy named Mark from the XP community, responded and wrote, which they could draft in a couple hours. It's no more a delay tactic than when Ripple recently did the exact same thing. And so attorney Rispoli wrote, yes and yes. I don't fault Ripple or SEC for their last few supplemental filings. And, that's something that I really hadn't thought about, but it actually is a really good point. All of these filings, including Ripple's most recent supplemental filings, which I covered on this channel, that could have impacted Judge Torres's release. Could have in theory. Now, maybe she was nowhere near the point where she's going to share her decision regarding summary judgment. But I'm just saying, if she is at a point where the release was imminent and she's like, yeah, I'll just do that tomorrow. Then if she gets something new, we're like, okay, well, hold on, let's tap the brakes, got to read this, digest all this, and figure out in what way it applies to this case, if at all, and how this will, if at all, change my rule. Like, that's what she would have to go through and think. Now, given that it's been however many weeks, or maybe it's been over a month at this point since the last supplemental authority from Ripple, and we still haven't heard anything from Judge Torres up to this point, I'll go ahead and speculate that, Judge Torres wasn't about to, submit a final ruling. I think that's pretty safe to say here. But if she was about to in this instance, then yeah, the SEC filing this would potentially slow it down. That's the point that attorney Fred Rispoli makes. Then there was also this. He wrote, it doesn't have to be a delay. Judge Torres can have her clerk upload her ruling in the next 5 minutes. Throughout this case, she has given the other party time to respond to an opposing party's supplemental filing, though. Ripple could file a response to this in under 2 hours. So there you go. So he's just saying, Ripple could file quickly, in which case it would be even less likely to have a delay. But just if you look at Judge Torres' behavior, she has allowed time for each party to respond. And it doesn't mean she has to, but it's reasonable to suppose that she might. Although I will say that Attorney Morgan doesn't seem to agree on that particular point. And so Attorney Morgan wrote, I wanted people to know this will not cause delay and is not a binding precedent on the judge. In the SEC v. Commonwealth Equity Services case, the district court judge distinguished Upton v. SEC, on which the defendant in that case relied and on which Ripple also relies. Does not mean Judge Torres will necessarily distinguish Upton v. SEC rather than apply and follow it on the different facts in the SEC v. Ripple. Yeah, so what he's noting there is simply that although there is that overlap of commonality between what happened in the Commonwealth case and then how Ripple's noting, hey, Upton applies here, if you look at these specific facts and circumstances in the SEC v. Ripple case, Upton may not end up being a determining factor on how the judge rules, if at all, regarding the fair notice defense. And then Attorney Morgan says, it is worth noting that in the case on which the SEC relies, the failure to disclose conflicts of interest, which was the subject of the complaint, had been an industry-wide standard of conduct for 50 years. Quite different to the infancy of the crypto market and uncertainty about whether and to what extent securities laws apply. Yep, and so that gets to a point that I was making a bit earlier in the video. There's way more confusion in this industry than an industry that's been around for at least half a century. So, and how to conduct oneself in that type of industry. So we can all wrap our brains around that. And again, separate from that, the facts and circumstances are also quite different. So in the end, I don't think that this is something that's going to impact anything regarding the stuff that most matters to XRP holders. In particular, Are secondary market transactions of XRP some sort of illegal securities infraction? Is that illegal? I don't think that's going to impact it at all. In theory, if things go horrible for us as XRP holders, though, which is possible, I just don't think it's likely, that's when this could potentially, to some degree, negatively impact Ripple. But really, at that point, it'd pretty much just be Ripple. So here you have an XRP community member who goes by the name Crypto Consuela, referencing Family Guy, of course. I gotta love that lemon pledge. Consuela here writes, Senor Hogan, on a scale from 1 to 10, how aware is the judge that the future of an entire industry and people's careers depends on her decision? And how impartial is she to that fact? And I always find that question to be fascinating. It's something that I've been talking about just a little bit here and there recently. And my personal perspective is, she knows. Yeah, I think she's pretty damn aware. It's crystal clear. When you got somewhere in the neighborhood of 76,000 XRP holders represented by Attorney Deaton, unprecedented, never happened in history. Look at all the amicus briefs. And then on the bright side, it's not just that people are coming and say, hey, look at us, we want to participate in this case, in this capacity, and then her allowing it. It's not just that. It's that, well, actually, maybe it is. It's largely that, actually. It's not just that the people are doing it, it's that she's listening. Yeah, actually, it is the point. She's listening. She does want to take, because she didn't have to take in any of this information or allow all these amicus briefs. Didn't have to allow Attorney Deaton to do anything in this case, but she did. And so it tells me that she came in as a blank slate. In all likelihood, that's what it looks like. And just wanted to be informed. And so Attorney Hogan responded to that and said, I don't know, to be honest. She has definitely been cued in that this is not a normal case. And so I'm willing to go out there a little bit further on a ledge than Attorney Hogan. That's fine. But Attorney Hogan still does agree that, looks like Judge Torres has probably been able to sniff out the fact that this case is not the same as other cases. One of these things is not like the others. It's the Ripple v. SEC case, or SEC v. Ripple case, whatever. Then there's this. Somebody from the community named Dennis wrote to Attorney Hogan and said, if XRP sold in the past and today is deemed a security, does that legally give all the benefits that come with? I mean, can I go to Ripple and say that I have a share of the company? Honest question. And Jeremy Hogan wrote back, because that's a totally fair question. Jeremy Hogan wrote, unfortunately and ironically, no. Of course not. Because you would think if there's that type of infraction, if that's the decision we come to, and typically there's some sort of contract indicating additional responsibilities, there would be something attached, and you'd have to go back and say retroactively, hey, Ripple, look at all these as a requirement of all these illegal infractions right here. You got all these responsibilities, all these people that are holding XRP. That would logically follow, right? And that's why Attorney Hogan says, ironically, no, there would be no additional responsibilities for Ripple whatsoever. And not that I'd want them to have such responsibilities, because I don't think that makes a damn bit of sense. All I'm saying is that the logic would follow that if that happens, there should be, you would think anyway, there would be something that must be done right there, right? And that's why Attorney Hogan says, ironically, no. So there we are. This world does not make sense. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.